Hey, so shout out to the lovely people in Carhart who gave us some lovely coffee.
Right, so what we have here are a couple of bankers. Bankers? No, wait, that's wrong. Sorry, hang on. Let me just check my script. Yep, sorry, it's really annoying when this happens. Just bear with me. Ah, yes. What we have here is a couple of No, wait, YouTube will ban me forever if I say that. I'm in enough trouble with YouTube already. Okay, what we have here is a couple of auditors stroke vloggers type people or whatever. It's Absolute Audits and Charles Veitch, and they're going to visit a bank, hence my confusion. Apologies for that. I naturally took them for bankers.
And chocolate croissants, we approve.
Take your fucking big hoop earrings and fuck off.
Focus.
Well, how can I make this about me?
She wasn't
to beat me up.
She wasn't in focus, unfortunately.
They're off for a shoplifting Primark anyway.
I promise you they're definitely off to the bank at some point in this. Let's skip forward and find it.
Action! Action!
Huh?
What?
Just take
I'm
this.
just getting some snaps through the front door.
Why?
Why? Why, I hear you ask? Well, because taking snaps of the front door of the bank with people coming in and out is perfectly normal. Everybody does it, don't they?
Just because I want to.
Why?
Oh, do we have to say?
Yes, it's a bank.
Oh, but you keep money in.
It's a security issue.
Do you keep money in there?
I've got...
Wait, at what time do they...
It's not really a security issue, to be fair. If they really were up to no good in that sense, they would be less conspicuous about it. It's really more of a privacy, data protection and public order issue, as I'll explain. But they are up to no good in a different sense, that they're just out to wind people up, not as a good-natured joke, but because they're bankers. Sorry, wait, they're not wankers. Bankers. 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 Honestly, no truth of a lie. I meant to say bankers there. That was a genuine Jeremy Hunt moment. You believe me, don't you? Don't you? Look, while I sort out my script, you just watch the video, alright?
What time do they deliver the money? What time is the money delivered?
Get out.
No, but what time is the security shift handover? We just want to know when's there the least amount of security here? Oh, here's a...
Notice how these two bankers, I mean vloggers or auditors or whatever they are, don't care about the privacy of the staff member or the lady customer coming out of a bank. Of course, they're supporters on YouTube, they're fellow bankers. Just hang with me here while I get my language right. I meant to say they're fellow auditors or whatever. They will say there's no privacy in public. I'm not sure that's true, but they're experts. They know everything.
Can I just get a picture of the keys? Quickly, just a quick picture of the keys.
And what is the combination for the safe? That's the last question. Any safe combination? Wait, but we're NatWest customers.
Come on, Joe.
The lady needs to go banking.
It's not allowed.
That poor lady there has done the only sensible thing, which is to shut the door and wait for these bankers to clear off and pester somebody else.
Banking, that's it. Go with Nationwide instead. There's your customer. You lost your customer.
Go and push the button.
This is costing the bank customers, but these two don't care about that. They just find it jolly funny.
Wait, press that. Wait, is this...
You need to stop videoing, seriously.
No, it's okay. It's just, we just need to know what time is the money delivery here.
Right, I've been joking around at the expense of these wankers for long enough. Sorry, bankers. Bankers. Let's be serious now. Perhaps the bank staff could have dealt with this in a more low-key way and just ignored the filming and questions and pestering. But at the same time, somebody standing outside the business filming for the sake of just annoying people is going to be off-putting for staff and customers. Now, if this was a grocery shop, a supermarket or electrical goods store or something like that, it wouldn't matter, and I think there would be a very good argument that these two bankers would be entitled to film and be left alone to film, exercising their liberty to do so and ultimately falling back on their Article 10 rights, which I think in the case of a normal retail shop would override any right to privacy in most situations, especially if the method of filming was relatively unintrusive. You know, they're not sticking their camera in people's faces or making a point of embarrassing people and so on. Obviously that doesn't apply here because a bank is a bit more discreet in the first place, and although the bank has an open position on the high street, filming people coming in and out in a way that can identify them and filming staff isn't necessarily the done thing. And a claim of privacy would be on a much firmer footing. Anyone they capture on film could make a privacy complaint to YouTube for a start. But there's a bit more to it than that. What I have in mind as I see this incident unfolding is Section 5 of the Public Order Act 1986, maybe even Section 4. Before we go into that, let's watch a bit more.
What time?
No, you need to stop videoing now before we phone the police.
No, but just when the police come, they might help us to do the. We just need to know
Yeah, of
what
course
time
they
the
will.
security handover is.
You need to leave.
Hi, name's Charlie Veitch. How are you? It's okay, we're filming. Imagine if we told you off for filming.
Well, yeah.
I don't mind. Name's Charlie Veitch. Enjoy it.
The bank staff can film these two bankers, and indeed I would say they should for reasons of site security and crime prevention. They will realise that this whole thing is a prank for the entertainment of idiots somewhere, but at the same time they have to record incidents.
Let me up. Hello.
Again, filming customers coming out of the bank. I think it's a bit naughty, to be perfectly honest. Even if there were no significant issue in it in law, it's just not the done thing in terms of social mannerisms. A bank is a place where people expect confidentiality and a degree of privacy, albeit that their affairs are largely being conducted in public. The CCTV is passive recording and is there to ensure security, and everyone consents to it by entering the bank. It doesn't breach any expectation of confidentiality or privacy. None of these people consent to having a camera in their faces. It would be a completely different matter if these bankers filmed the bank from a wide angle, so the filming was being done of the building as a whole, with perhaps the topic being that particular bank or banks in general or some aspect of banking as a subject. In that case, there are no real significant privacy implications if somebody just happens to be walking in and out of a bank and gets caught on film, and that person can always be blurred out without any hindrance to the message and the purpose of the film itself. What these bankers are doing is filming people up close at the entrance, and that is their purpose. They are not actually interested in banking or any serious discourse on the topic of privacy and confidentiality in retail banking. They're out of order. It suggests either that they have a callous frame of mind or just have no respect for other people, or it suggests that they're socially autistic in some sense, or perhaps a bit of both. What does the law say about it anyway? Well, first of all, these two bankers are not actually on private land, or if they are not on land occupied by the bank, and they are not putting their cameras up to the window or anything like that. So the bank can't claim trespass, or probably can't. You'd certainly have to come up with a pretty creative interpretation of the relevant law to make out a claim for trespass, I think. The bank also probably can't claim harassment, whether civil or criminal. That's because both civil and criminal harassment require a course of conduct, which is a minimum of 2 occasions. The same applies to individual bank staff. Now, as I've explained in other videos, 2 occasions could be these two bankers walking away to pester and bother somebody else for a few minutes nearby. then returning to pester the bank. Then you could, I only say could, have a course of conduct which forms the offence of harassment, and a civil claim by the bank as well. But we haven't seen that happen yet. Now, I say probably can't claim harassment rather than definitely, because there is an offence in the Protection from Harassment Act 1997 in Section 1, subsection 1A, where the harassment is to persuade someone not to do something he's entitled or required to do, or do something he's not under any obligation to do. And if we now go to Section 7.3b of the same Act, we see that an offence is formed under Section 1, subsection 1A, if it takes place on at least one occasion. That's interesting. But that offence in Section 1, subsection 1A was intended for situations where, let's say, prominent people, certain political groups, large companies and the like, are put under improper pressure, and allows the people putting them under this improper pressure to be prosecuted for harassment, or indeed sued. Potentially that offence could apply in situations involving auditors that are similar to this, so it's something for us to bear in mind for the future, but I don't believe it applies here. For anyone interested in the law on civil harassment, the major case is a 2010 High Court case, which is Bruce Dowson and others and the Chief Constable of Northumbria, and the link has been posted in the description. I think, in terms of a law in this situation, I think this is a public order, privacy and data protection situation. In regard to public order, I normally stick to the Section 5 offence under the Public Order Act 1986, rather than Section 4, because in non-violent cases such as this, Section 4 requires proof of intent, whereas Section 5 requires no proof of intent to form the offence. That means Section 5 is easy to apply in cases like this, where a couple of I was going to do a Jeremy Hunt there. A couple of bankers are making a nuisance of themselves. Anyway, we'll be looking at public order offences, but I've said enough for now. We'd better watch a bit more of this first.
Oh guys, it's the money man, NatWest money man. 200 grand in that. Look, it's got a big lock on it, look. Oh, money man.
Permission to film me. So
I'm not filming, I'm taking pictures.
well, I don't give you permission to take pictures of me.
Well, move out the way then.
No, because I'm in work and I don't give you permission.
Well, go. You're not in work out here, are you?
Yeah,
Go back to work.
but I don't give you permission.
Go back to work.
Did you get that? I missed this. You got it, didn't you? Good man.
Most of it, yeah.
Taking photos, I don't give you permission to take my photograph.
Can you speak up a bit? The camera doesn't pick it up.
But I don't give you permission to take my photograph.
Albert.
These two are bankers, let's be clear about it, and my total sympathy here is with this lady because it's obvious what they're doing, but we can't look at this emotionally, we have to look at this in terms of law. In law, they don't need her prior permission as such to film or photograph her in this way, but as is always the case with auditors, their understanding of the law is a bit simple. The law isn't simple and it never or rarely is black and white. A number of points arise. First, as I've already explained, the photography being carried out here is intrusive rather than general or thematic. It's not as if they're stood some distance from the bank filming the building and bank for the purpose of a documentary or academic study or just a street vlog about that particular bank or that banking chain or banking as a topic in general. If that were the case, the privacy issues are dialed down because it's not their intention to intrude on anybody's private life, and anybody they capture in the film is captured purely incidentally and if necessary can be blurred out without any detriment to the film's purpose. What these two bankers are doing is the opposite of that, and that is what potentially brings us within the various legal regimes of privacy and data control. It's what makes the capture of people's faces in public potentially classifiable as personal data for the purpose of data protection and private information for the purpose of general civil law. The whole point of what they're doing, their own methodology, is to provoke a reaction by filming people intrusively, up close, in a way to needle and goad individuals, and they can't then blur these people out without being detrimental to the film. Therefore, the purpose is intrusive, and the people they are filming aren't just walking down the street or browsing a grocery shop or electrical store. They're at the bank, which is privacy sensitive. That brings us to the first question. How can people captured in these videos enforce a right to privacy? There are 3 ways to do so. First, rights against auditors and duties of auditors under the data protection regime can be enforceable. Second, we can consider the indirect effect of Article 8 of the Schedule to the Human Rights Act. Third, we have to consider the tort of misuse of private information, which is a civil wrong. Taking the first one, which is data protection, most of these auditors think they are not subject to the formal data protection regime. In fact, they are. Just to recap, auditors think they benefit from one of 2 exemptions, either the domestic purposes exemption or the special purposes exemption involving journalism, art, literary works, academic work. If your channel is monetized, however, you do not benefit from the domestic purposes exemption because you cannot argue that your channel is purely a hobby for private purposes or for any domestic purpose purely. Secondly, even when we can give an auditor the benefit of a doubt, which I prefer to do, and say that the journalistic exemption potentially applies, the auditor still has to justify it. He still has to show in each instance on a case-by-case basis that he reasonably believes that the journalism he is carrying out is justified in the public interest, and that the various duties and obligations of data protection would hinder and get in the way of that journalistic purpose. So it's not as simple as they make out. Also, it's not a blanket exemption anyway. I explained in another video that the exemption for journalism does not apply to all the data protection requirements and does not exclude all those or accept all those requirements. Even if we do say that Charles Veitch and absolute audits are exempt in this video, the ladies who are captured here on this video still have the following rights. They can demand the name and address of Charles Veitch and absolute audits for the purpose of data protection compliance. They can demand that this auditing video is taken down pending legal claims and notices to the auditor and YouTube. They can demand that the auditors manually blur their faces rather than rely on automated blurring, and they can demand that YouTube manually review the videos in the event that a privacy takedown notice is not acted on. They can demand that the auditor does not use their images in any other videos for promotion of their channels. They can complain to these auditors and about the auditors to the Information Commissioner. They can require that the auditors adhere to the obligations of data controllers contained in Articles 24 to 43 of the UK GDPR, most of which will still apply to auditors even if exempt. And as a means of enforcing this, they can take 2 further steps. First, a privacy and data complaint to YouTube can include a reference to the obligations in Articles 24 to 43 of the UK GDPR, which apply both to the auditors and YouTube, and the complainants can also demand that the auditors produce a copy of their privacy and data policies to reflect these obligations, or face a complaint to the Information Commissioner. Furthermore, the auditors, even if they are exempt, are still required to register as data controllers with the Information Commissioner, and Charles Veitch is not registered currently. I know that because I've checked, which means he is in breach of Regulation 2 of the Data Protection Information and Charges Regulations 2018. The Information Commissioner's office could fine him for this breach. Tut tut, Charles, you're a naughty banker. Now, quite apart from all that, what we also have to consider is whether the content of this audit or the visit to the bank is journalism or an artistic work in some way at all. We have to be fair and acknowledge here that journalism for these purposes is very broadly defined. The relevant case for anyone interested is found in the Satamedia case, a European Court of Justice case in which the court made clear that journalistic activity should be broadly defined and interpreted, and in the case of Sugar and the BBC, a UK Supreme Court case in which Lord Walker opined that alternative media output could be covered by the art and literature part of the special purposes exemption. However, I don't believe this activity that Absolute Audits and Charles Veitch are engaged in is journalism, or for that matter artistic or academic or literary. It's clear that the journalism exception is a privilege which is afforded to journalists by the state, and with that goes certain obligations, including to carry out responsible journalism. The motives of Charles Veitch and Absolute Audits are malicious, and they are showing no respect for privacy in a sensitive area. I would also argue that by allowing that this is journalism, that could lead to a perverse result, because compliance with the Data Protection Act would hinder them. For instance, if Charles Veitch and Absolute Audits had to provide these ladies with their personal details and a means for complaint, and also blur out their faces, that would completely defeat the object of what they are doing, which is why they never reveal the names of their channels, and they are never honest and transparent about the purpose of what they are doing. I think what we can say overall is that the type of activity that Charles Veitch and Absolute Audits are engaged in here could be journalism in the sense that it exposes attitudes to public photography and involves an element of comedy, but only if it is compliant with the law and respects privacy. That's the way I would summarise it. That's the principle. And the problem is that they don't respect the law or privacy, and for that reason they should be exposed, in my view, to the full rigours of data protection and not be allowed the exemption, which is a state privilege for responsible journalists. Right, now let's turn to the Human Rights Act. The right to respect for your private and family life is enshrined in Article 8 of the Human Rights Act. Article 8 is not of horizontal effect. In other words, you can't bring a claim against somebody else based on Article 8. The purpose of Article 8 is to regulate the relationship between state and citizen, but the state includes the courts. So in effect, this means that businesses, companies, organisations, public bodies in the UK, even individuals, must have regard to Article 8 when making decisions, because the courts will ultimately have to take Article 8 into account when deciding cases. It follows from all this that anyone captured in that film can make a privacy complaint to YouTube, and it is likely that the complaint will be successful. Now let's turn to the tort of misuse of private information. This is a civil wrong that effectively replaced what was Section 13 of the Data Protection Act 2018. Section 13 allowed data subjects who had suffered loss or distress to bring claims against people who had breached their data, claims for damages. This cause of action was effectively abolished by a judgment of the Court of Appeal in the 2015 case of Vidal-Hall and Google, and it's that case that gave rise to the new civil wrong of misuse of private information. The court decided that an action could be brought for the misuse of private information even if no actual measurable monetary loss could be demonstrated. How is that relevant here? Well, given that Charles Veitch and Absolute Audits are filming for money, they fall fully under the data protection regime, and as I have demonstrated, they are not availed of any exemptions, thus have a duty to deal properly with the private information of anyone captured in the video. But is the image of somebody in a bank entrance classed as private information? Well, it's a public place. I think even so, there is an argument that they are capturing private information analogous to personal data as defined in the Data Protection Act because of the manner in which they are doing it. As I've explained, they are not just generally filming a location, they are filming specific individuals up close and in an intrusive manner. Since it appears they are not compliant with the data protection regime anyway, it would seem likely that there is an actionable claim for misuse of private information, if only due to their non-compliance. If it could also be shown that they obtained images of bank staff and customers while engaged in criminal behaviour and then used that personal data, then this could be the basis for a civil claim for misuse of private information. That brings us to the criminal offences that may be relevant. I would like to look first at Section 78 of the Police Crimes Sentencing and Courts Act 2022, which contains a new offence of intentionally or recklessly causing public nuisance. This offence was introduced in reaction to extreme protesters such as Just Stop Oil, but it seems to me that it could be applied to a wider range of circumstances. I don't personally necessarily approve of the way that the state's powers are being expanded like this, as it could be a threat to civil liberties. But at the same time, the purpose of this channel is to comment on how the law affects auditing, and Section 78 seems relevant. One of the ways the offence could be formed is Section 78 1b2, which is obstructing the public. Seems to me that both Charles Veitch and Absolute Audits must know that their actions are causing an obstruction at the bank entrance. An obstruction need not mean that people are stopped from passing through. The staff can just open the door and let people in and out, but they have had to shut the door due to the presence of the auditors, and the auditors must realise this and are continuing with their behaviour. The fact that the bank staff are the ones closing the door is immaterial to forming the offence. In support of this, I'd refer to the sentencing remarks in a criminal prosecution for obstruction under Section 78, which was a case of Rex and Trowland and Decker, a link to which is in the description. In that case, it's clear from the facts that the police blocked the highway, not Trowland and Decker, but the police decided to do this due to the actions of Trowland and Decker. In other words, a prosecution for intentionally or recklessly causing public nuisance by obstruction under Section 78 needn't involve the perpetrators actually committing the obstruction. It can just be that their actions intentionally or recklessly led to the obstruction. Now I'll turn to Section 5 of the Public Order Act 1986. What that states is that it's an offence to commit disorderly behaviour within the hearing or sight of a person likely to be caused harassment, alarm or distress thereby. Note that this does not require any intent to cause harassment, alarm or distress, nor does it require that anyone actually has been caused harassment, alarm or distress, only that they are likely to be caused harassment, alarm or distress. That being the case, I think the behaviour of Absolute Audits and Charles Veitch does amount to a Section 5 public order offence. Anyway, the incident isn't over, so let's take a break from the law and watch some more of it.
It's okay, you come out well. She said it doesn't give permission to take a photograph, but is she not messing with my right of expression?
Well, she can't mess with your right of expression there and then, can she, Charles the banker? There is no prior restraint on you that stops you filming, unless you're under a community protection notice or criminal behaviour order or a private injunction. But if you keep going on like this, one day you might be under one of those things, and you may find that your rights of free expression are lessened for the sake of the rest of us, so that the rest of us don't have to suffer under detailed prescriptive laws that say precisely when and where one can take photographs. The reason we don't have such laws is because in the past there weren't so many idiots like Charles Veitch around. A common cultural understanding reigned in society in which we all self-regulated our behaviour, and this allowed us to enjoy relative liberty under law without the need for detailed prescriptive laws that treat us like children. Yes, Charles Veitch does raise a valid point that he has a right of free expression, particularly under Article 10, as well as the ordinary liberty to film, and nobody wants to interfere in that right or make photography a crime. But I think he's missing the point, which is that there are social mannerisms and nuances that have to be taken account of that allow us all to live together peacefully. And once the social fabric of society is disturbed, you then have the risk of intervention in the form of prescriptive repressive laws that restrict everybody. The law as it is now reflects society and has become more complex and refined to reflect the changing needs in society. The point I'm driving at here is that the problem isn't that Charles Veitch and Absolute Audits are filming. It's not filming that, as such, that is a problem. It's the way that they're going about it. Nobody wants to interfere in this man's rights, but at the same time, realistically, his rights have to be balanced against other people's rights. Sensible, mature people are aware of this and exercise due care if they engage in public photography. Charles Veitch and Absolute Audits are not normal public photographers. They are out to provoke. I really feel for this lady, and one criticism I must make of the bank is that they should have had either a male member of staff there or a security officer of some description, or they should at least give her more support. She shouldn't be having to deal with this nonsense on her own. I would say the same if it was a younger, inexperienced member of staff of either sex. But there are certain situations, if we're being honest, where you need experience, and there are situations where, without wishing to be too old-fashioned, you need to have the presence of an experienced man to deal with it. As for what she should do, again, it's a situation that underscores why local beat policing is sorely missed. If there was a local officer on the beat around there who they could call on to have words with these two characters, that would really fill a gap and help the bank and their staff. There it ends. In summary, first and foremost, I think this was a Section 5 public order offence. Their use of filming was a pretext to engage in silly behaviour that caused annoyance to the staff, and I think the behaviour was of a kind that was likely to cause harassment, alarm or distress. Second, I think it is possible to apply the offence of intentionally or recklessly behaving in a way that causes a public nuisance, in this case in a way that leads to an obstruction, contrary to Section 78 of the Police, Crime, Sentencing and Courts Act 2022. I don't believe that the material in this incident benefits from the journalism exemption under the Data Protection Act and various rights and duties attached to the auditors under that Act anyway. For one thing, Charles Veitch is required to register as a data controller and he has failed to do so, which means he is in breach of Regulation 2 of the Data Protection, Information and Charges Regulations 2018. One reason I make these videos is that I hope watching them gives some vindication and comfort to the victims of these idiots.